Today's webinar is on the sometimes convoluted and extremely fast-changing world of rights and licensing. All organizations using material produced by others are confronted daily with questions about copyright. Unless someone is hired specifically to manage copyright issues, copyright is not usually part of anyone's individual job description, and so staff lack the expertise to address these complex issues. As a result, questions are either managed haphazardly or not at all. Not dealing with copyright in the right way could be a lost opportunity, or worse, could be the start of a legal conflict. Our presenters today run AllrightsOnline, a consultancy specializing in copyright compliancy and risk mitigation. AllrightsOnline specializes in addressing the need for professional, educational, and informational support in the area of publishing rights and permissions. It also offers legal consultancy in these areas. Their clients include authors, rights holders, and their customers, R&D intensive companies, including pharma, chemical, and ICT, and all those active in e-commerce, including startups, because, of course, it's better to get it right from the get-go. We're lucky to have two guest presenters today. Berendina van Straalen is a certified mediator in copyright issues and has extensive practical experience as a researcher, translator, editor, and manager of subsidiary rights within the publishing industry. She has built up strong relationships with authors, research and development, publishers, the corporate industry, academics, and the big players in the information industry. Thanks to her experience, she understands that each department and every part of the business looks at copyright from a very different perspective. As a result, she designs and presents many in-house copyright training sessions for staff at different levels within companies, from everyday publishing to corporate level. As a service to authors, she has set up a copyright help desk and co-developed software to manage questions about copyright more smoothly. She's fluent in English, Italian, and Dutch, and has business-level fluency in German. She also has a good understanding of written and spoken French. Our other presenter, Chris Kluiters, is a seasoned publishing professional with many years of commercial, contracting, and licensing experience with major esteemed publishers. He has given many public presentations at conferences and customer panels. For more than 10 years, he was a trainer and study mentor on e-publishing for the former Dutch Book Trade Organization. Earlier in his career, he started and co-organized the first summer schools on digital libraries with Tilburg University in the Netherlands. Throughout his career, he's built up a unique perspective on rights issues, both in global as well as local and regional markets, particularly in Southeast Asia and Central Asia, including India. He has a master's degree in intellectual property and technology law from Liverpool University, specializing in text and data mining and contract law. As a current board member of the Dutch Open Access Platform for Legal Commentaries, and as former VP of the Dutch legal search engine Rechtsorder, he also possesses specific legal publishing and software expertise. Like Berendina, Chris is a linguist and is fluent in English and Dutch. He also has business-level fluency in German. I'll now hand you over first to Chris and then to Berendina. Thanks very much indeed.
Good afternoon, everyone. Thank you, Barn, for the nice introduction. We're very happy that we have a nice audience with us today, and indeed we're going to discuss and introduce you to some of the licensing challenges that are ahead of many of you listening to this webinar. I will first give you an introduction on the more legal conditions under which licensing agreements need to be made, and then Berendina will go into the specifics of the licensing itself. I hope that everyone can hear me well, and let me immediately start. As Byron indicated, about a year and a half ago, we started AllrightsOnline, specifically helping libraries and publishers with their licensing challenges. And as you know, there are licensing or similar agreements in in every organization in the information industry. You have come across author agreements for journal articles, consent to publish agreements, agreements for books, agreements for editorial board members, contributors, open access agreements, library agreements, metadata agreements, licensing for other data, agreements for aggregators for platforms such as Ingenta, agency distributor agreements, the reuse of data, rights and permissions. It's too much almost. We need to go on. And we have seen in the last year and a half that actually in all these areas we have now advised publishers and libraries on these agreements. And one of the reasons why that is that the STM industry in particular is, even today, with the large publishers still dominating the market, it still remains a cottage industry. And what I mean with that is that you will find a lot of publishers in the long tail of journals and books, and a lot of these publishers do not have a dedicated legal counsel in-house. And as a result, it is sometimes very hard to discuss with these publishers all the agreements that need to be in place to be able to do the business. And we hope today to give you a little bit more background of all of this. Now, why is copyright and licensing in the center of attention? As we all know, there is, since online publishing started, which is actually at the end of the 90s of the last century, globalization is the key word. And that, as an example, makes it possible for the third world to have access to a lot of material where they did not have before. And that opens up a lot of challenges. Online doesn't have any borders. The internet and the new technologies created so many new challenges, ranging from the hyperlinking, the copying, the text and data mining of big data, intermediary liability. In other words, what is the responsibility of the internet service provider? And that could include websites or hosts at libraries. User-generated content, that's actually too much. And lately we've seen also challenges with open access and blogs, for instance. We've seen growing governmental interventions in Europe, for instance, in the digital single market. And this all actually, as a base challenge, it is the balancing act between authors, rights owners, and users. And if you ask today a publisher how they feel about their rights, you will hear almost always that they feel that their rights are deteriorating, which is a very interesting comment, because if you would ask that very same question to authors or to readers or to libraries, they would feel the exact same way. They would also say, well, my rights are really deteriorating. And that balancing act is at the base of many of the agreements that need to be negotiated between all the stakeholders in the industry. What is the balance that you're trying to find in your agreements? Then there is a growing populism that everything should be free. That started already when online information started, but it has become more so in the last 3 to 5 years with peer-to-peer networks, Sci-Hub, open access developments, and ResearchGate or similar types of developments. Then there is a complicated international law enforcement. Why is that important? What I said earlier about the cottage industry, if you have an agreement with a smaller publisher, then it is very unlikely that that publisher will have a possibility to do any kind of law enforcement, because they are too small for law enforcement in many other countries, because they simply don't have the expertise to do that. And overall, you could even argue that there is little or no knowledge at all with many of the stakeholders, including some of the rights holders themselves. And stakeholders include authors, readers, or libraries for that matter. So we get, in the last year and a half that we started, we get so many questions from from these stakeholders about what you can do or you cannot do based on the licenses, you will not believe. So what are some of the legal contemporary challenges of all these agreements, of all these licensing? We have the development of e-commerce, for instance, the click-through licensing or the jurisdiction under which the licensing is done and the e-commerce takes place. We have developments under contract law and commercial law. For instance, the famous most favored nation clause you will find that in a lot of agreements, for instance, with aggregators. We have, I don't need to emphasize this because everyone is bombarded with the emails. We have data and privacy legislation, who owns what, the protection levels and the fines. Then there are developments on competition law. For those who are interested, I would point you to Elsevier versus Louisiana State University as a court case, or to the documents behind the Springer Nature merger. You will find interesting background on what is and what is not possible under competition law. As we all know, hopefully, copyright is very much part of the intellectual property law, and there are still a lot of developments also in other areas of intellectual property law, such as trademark law, design law, portrait law, or patent law, let alone the copyright itself. There is new copyright legislation in the EU, as we all know, and there are a lot of interesting and new developments there. And there is the copyright legislation developments in Canada, Australia, and Germany. Overall, it pays to know the differences between common law and civil law, because the legal systems in the UK, Commonwealth countries in the USA is very different compared to some of the other EU countries, such as France, Netherlands, and Germany. And then there's always the interesting case law to be followed. I've listed here just three of the more, well, they're not that recent anymore. The University of New Delhi versus Oxford University Press, VG Ward versus Vogel, and Hewlett Packard versus Reprobel, as some of the cases where you can find some interesting court cases that have developed into policies at publishers. When we now look at the international legal context, if you're going to work on licensing, it pays to know the international legal context. And I have to admit, when I was making this slide, I omitted number 5, which is clearly US court cases and US law. But if you are studying into the legal context, you should look at the treaties such as the Berna Convention, the World Trade Organization, TRIPS agreements, the WIPO Copyright Treaty, or even the human rights section of the ECHR. There are by now 9 European directives related to copyright, and they all say something about the way some of these licenses need to be formulated or can be followed up on in terms of law enforcement or related topics. Another area which is quite interesting is the case law of the European Court of Justice, because and this is point 3 and 4 is actually, you could read that together. What you see is that the European Court of Justice has some sort of an activist role these days. They are trying to, a lot of the national courts go to the European Court of Justice to get a statement from them as to how they should interpret certain developments. Some of the cases that I didn't list here, which are interesting, for instance, is in the Netherlands, where they asked the European Court of Justice how they would look at e-book lending, for instance. But you can also see here, GS Media is about linking content from one document to the other. So these are some of these international legal contexts that you need to understand and need to be able to interpret it, whether it's of any importance to your own legal development and licensing. I would now, this is more of a general comments about the background under which licensing is dealt with. And I would like to give the word to Berendina, who will take you more into the details of the licensing itself. Berendina?
Thank you, Chris. Hello, everybody. I will start this slide with, let's say, a small slogan that I use when I'm going to my customers, is you can only sell those rights that have been acquired. And it sounds very logic, but that's the way it is. And then another thing that I think is very important to have a look at is the definition of the license. And why do I think that the definition of the license is important? Because every single word in this license definition is important to have a look at. And I will now read out the definition. A license is a legal agreement which allows the owner, that is the licensor, of the property to grant a manufacturer or a retailer, the licensee, the right to use the property on specific products, usually in a defined territory over a defined time period. And all those words are actually items that you have to look at when you are considering licensing, not only in your licensing in contract, but also in your licensing out contract. But before we start with licensing in, I would like to say something about maybe the audience. As you can understand from our first start, we will mainly approach these issues from the publisher's perspective. However, in case there are also participants that with a library background, it is certainly interesting to know how publishers face these issues. And if some of you wish to know more about library licensing, that we will only have a small reference to in these presentations, we are most willing to help you out after this presentation. So let's move on with the licensing in content. Licensing is important because when you wish to exploit the content, you need to know whether you have the right to do so. In licensing out contracts, there is a clause stating that the licensor has the full ownership and is in the position to license out content. Therefore, it's important to have the criteria of ownership registered. There are different types of transfers of rights. The full transfer of rights, which is the registration of the copyright that has been transferred from maker to the publisher, or work for hire, determining which copyright is transferred to the publisher and which rights are with the author or the company. Rights associated with a takeover, merger of a company. Are the transfer of copyright to the acquired company equal to the rights of the publishing house that purchased the company? Open access. Which open access model does the publisher apply? There are several models from full open to restricted versions. Then you have the transfer of rights of third-party content into publishers' products. Content through permissions, for instance, into the publisher's content. Then you have co-publications, which exploitation rights have been agreed upon. And then hosted in content from other partners onto the publisher's site. And why is it important to manage those rights? Content is licensed in different conditions for different purposes. As a result, there may be licenses for distribution purposes only and licenses in which all rights have been transferred to the publisher. The transfer of rights may be for one edition only, a few years, or for the copyright period as defined by the national law. And mostly the products are registered for the distribution channels of the publisher herself. The exploitation of rights associated with licensing out through third-party channels is an activity that has hardly registered in the licensing in contracts. And as a result, a system in which rights are managed may not give sufficient information about the licensing out opportunities. This means that for certain licensing out contracts, the contracts about licensing in rights will have to be checked manually. Open access is part of the publishing program and the aspects to face when licensing out. Open access has different versions. It's advisable to check whether the international version suitable for international market is adopted by the publisher. The license itself has different types, CC BY, NC, NC&D, share alike, and maybe others in the future. And the license type will indicate in which way the article can be used. An open access article is always freely available for individual reading. When the publisher distributes open access content together with non-open access content, it is important to register the type of license that is applied, not only in the system, but also on the opening page of the content and in the associated metadata.
Yeah, Berendina, maybe I can just interrupt for a second.
Yes.
What we're currently doing, and I cannot disclose the organization that we're doing it for, is that we actually have listed all the open access related licensing issues for this organization, and you will be surprised that where in the past you had a agreement between a publisher and an author following a certain structure, and we have started looking into this structure, and almost at every item in those contracts you will now find open access related topics that need to be addressed in those agreements, and that's actually a challenging task, almost daunting, but this organization I think will really benefit from that. But I thought it would be good just to mention that.
Yeah. Then, so as I said, only those rights you have, you can acquire it, you can sell. Now we go to the licensing out part. There are different ways to look at licensing out. It's sales from the publisher to the end user, and this concerns the sales of a single title, single article the publisher has on its own platform or host, and to sell the content to an end user. The end user is an individual and is interested in a book, a journal, or a single chapter or article. And the sales can be through different media, print or electronically. When it concerns electronic sales, it is important to verify whether the transfer of electronic rights for each single item that is sold has been assured. Third-party license in content is usually not allowed to be sold without a special agreement of the copyright holder of that content. With regard to library sales, the publisher has its own platform or hosts his content on an external platform to sell the content to a library. This kind of sales requires a library contract for one site or multiple sites. The terms and conditions for the end users of the library have to coincide with the rights transferred to the publisher. When you think of sales through distributors, the publisher uses other distributors' agents to sell the publications on their behalf against a commission. This enables sales into regions and to customers the publisher would otherwise not reach out to. The terms and conditions to the end users of the distributors have to coincide with the rights transferred to the publishers. Then you have sales through third parties, responsible for aggregated sales. Parallel to the aforementioned sales channels, there are partners that have either a powerful search engine tool associated with their sales, like Google or Amazon, or partners selling collections of content from different publishing houses that are gathered into subject collections. These kind of partners sell aggregated content. So to summarize, for the sales of content through third-party distributors, it is important to verify how the content will be used by the end user. For this purpose, it is important to read the contract between the third party and their end users, and in any case to read their terms and conditions. So to rehearse, when you license out, it is important to check the terms or conditions of you as a publisher, of you as a library, of you as the distributor, and of you and the third party partner. The reason why this is important is caused by the slogan I mentioned on the top of this slide and the before slide. It is not possible to sell a right that has not been acquired or obtained through a transfer. As a result, match the transfer of copyright to the publisher with the terms and conditions of the distribution channels that will distribute the publisher's content. And specifically check on the following aspects. What are the view rights on those platforms? Is it able to copy and paste? Is it possible to share? Is it possible to download, and how much can you download? Are alterations allowance possible? For instance, ProQuest does allow this. Reuse allowance. How much can you reuse and for which purpose? So licensing out of open access content has a different approach or an extra approach. The use and reuse of an open access article is depending on the license type. And as an effect, When included into third-party licensing, it is essential to examine the end-user agreement between your third-party partner and her end-user and their associated terms and conditions. In those documents, it is described what an end-user can or cannot do. And apart from checking rights in all contracts involved, it's also essential to evaluate the publisher's mission and policy and the aims and targets of the third-party vendor. This is essential to evaluate possible cannibalization. There's an overview of licensing structures, from ebook distribution to aggregated database. When deciding to collaborate with external partners to further distribute the content, it is first important to analyze the models you already have. That is your own models as a publisher, the existing models you have with your distributors and what kind of models they apply. And then if you want to extend your distribution, the business models of the aggregated database. What are they heading for? What are their aims? What do they want? And then in the end, you have the document delivery, in addition to maybe pay-per-view on your proper website or on the website on which your content is hosted. Now, what is the benefit of different licensing models? It is important to determine what kind of sales efforts the publisher wishes to do herself and which activities can be taken care of by a third party. Then the mission of the publishing house will determine the type of products to be sold. The website on which the products are hosted and the sales force will also determine the opportunities that they can achieve. Once outlined the proper initiatives and capacities, it may be worth looking into business models and visibility through other channels. Some partners may increase visibilities and therefore result and generate more sales. Other partners may offer the preferred sales channels to those customers you are not able to reach out to. The benefits of proper clauses in licensing models. There are some must-have clauses for the publisher, and why would you need them? Once agreeing on a collaboration, it's important to include clauses into your contract with regard to an audit, for instance. It should be possible to check the third-party revenue and the associated publisher's revenue and match these against the royalty obligations in the contract. Check on the royalty clauses and the effect of open access models. This might have impact on a guaranteed payment, for instance. Moreover, it's important to consider the jurisdiction in which the contract should be defended in case of a conflict. Is mediation more interesting than arbitration? If there's a collaboration with third parties that compete with each other by adopting similar business models, it might happen that the third-party contract has a clause about competition. Depending on the publisher's situation and existing distribution contracts, this might not be a preferred situation. Key issues with aggregators and other types of third-party vendors. There may be that your third-party vendor has an additional business model which is not mentioned in the agreement. There might be a royalty calculation that is not clear enough, and you don't even know why you're getting this revenue and for what kind of use. Then another issue you have to look at is the direct revenue and the third-party revenue in balance? If your third-party revenue might be too high, it might be that your direct revenue is very low, or the other way around. And then, is discoverability a point? Has your content been found? And is that the reason why you don't see them back in your reporting, for instance? What are the authorized users allowed to do in the contract with the third party? And is this in line with the terms and conditions you want your third party to work along? And is it what they say that you're allowed to do? And then in the reporting, what kind of feedback do you want to have on the sales of your own content? Is it, if you want to do proper analysis in order to do a strategic sales in the future, you might wish to have more fields than your distributor or third party is willing to share with you. And then because you want to have this information, it's important to have an audit clause in your contract, because audits allow you to examine and to further investigate on what your third party has done with your content. And then, Chris, you want to share some examples of what we have been doing?
Well, we have what we have done is we have analyzed by now. Be surprised with already hundreds of contracts. We've encountered many different issues, ranging from third-party enabled business models that were not mentioned in the agreement, for instance, or we have seen that there is a proper description of the content delivery to the customer, which avoided exposure on the third-party platform. We've seen that royalty calculations can be sometimes quite vague. We have seen embargo periods on content that were sometimes not adhered to. So there's many different reasons. We have seen indeed what Berendina was mentioning earlier, that sometimes the terms and conditions of the publisher on their website were different as the terms and conditions of the aggregator website. So that basically means that you can do more with the aggregator content than with what the publisher, which is the same content, but then you can do more with it, or less for that matter. So there are very different developments that we have seen. So that is in a nutshell what we have been doing and what we've been seeing in licensing. So I think we should go now to your last
slide. Yeah. And then last but not least is, how do you get into the business of licensing, and how can you find your way to license out your content? There are different approaches. You can either you can also be approached directly by a third-party vendor. Now, well, there's one thing I would like to share with you, is that third-party vendors in principle wish to have a huge collection to offer to their customer and will approach the publisher with the idea of high visibility. It is good to find out whose visibilities they refer to, theirs or yours. Some of the third-party vendors do scroll publishers' list, and in order to achieve their goal to enlarge the collection, they will offer contracts. But does your contract really fit into this agreement? And then another thing you might want to analyze is the permissions you're granting on the content that is published. Through permission requests, there's often interest to clear permission for content into other products. But is this a real product, or is it a platform of a third vendor? And by doing this small analysis, you will find out that there may be a start of a new relationship with a third party. And then abstracting and indexing activities for your visibility of the content. Abstracting and indexing is an activity that starts very often at the permission department or at the marketing department, and also at editorial. You get the question, may I have this article abstract on this platform? And when you better look into this, it may be actually a good opportunity to increase your visibility through a partnership with this abstracting and indexing service. And then the sales activities. The existing sales reports from your sales reps may also give an opportunity where your content is going and if there needs to be an additional channel to work. And then there is the sales of document delivery that you can analyze to see which vendors you should, or which end users you might approach to have a direct relationship instead of going through pay-per-view. And then there's a strategic analysis. With whom do you want to partner in order to move on? And last but not least, and a little bit adheres to the last sheet Chris had, have a look at the technology. Technology really has a big impact on what you are going to license out. Open access has an impact on whether you can sell and in which conditions you can sell. Text and data mining. Do you want your customer to text and data mine all your content? And what is he allowed to do with it in case he does this text and data mining? And then the e-privacy. What are you going to do with all the customers that are visiting your website, and what do you do with their data? Data related to behavior of a user that's collected and should be anonymized. And if there's also a consent for open access to register, and what are you going to do with those cookies of those persons? And there are more things that we might address in the future. So this is actually our last slide.
Okay, thanks very much indeed, Chris and Berendina. You've got their contact details up there, so by all means feel free to follow them up with an email or a telephone call. Okay, question from Kush. As a small publisher, how can we go about tackling these challenges better without a legal team?
Yeah, that I can understand this question. The first thing, how to tackle, the first thing is to consider maybe in which direction you want to go as a small publisher, and then have an overview on how currently your sales look like, through which channels, and if you have the feeling that you reach out to all the customers you want to approach. And then if you think that there are other partners out there that you think they may be of help to you, then it first is good to have a look at how they would deal with your content, and if that's the way you want them to deal with it. And if that's okay, then you might have a look whether you have the rights that fit into their model, and then you have your discussions. And apart from that, another thing, I think for a small publishing house, it's wise to have a look at your visibility. Are you discovered through all the possible abstracting and indexing platforms? And can you talk with your third partners about dedicated sales products, specifically for your content or specifically for the topic that you publish? Chris, what would you?
Yeah, but what we have done now in the last year and a half, Kush, is that we have looked at several publishers, what we said earlier, hundreds of contracts. So we know by now what the benchmarks are for an appropriate contract between a publisher and an aggregator, for instance, or what an appropriate contract is for a publisher and an author. We have, apart from Berendina and myself, we have another lawyer connected with us, and the whole reason why we started AllrightsOnline was that smaller publishers are a bit reluctant, and I can understand why, is to go to a legal counsel around the corner, so to speak, for two reasons. One, they don't understand the STM industry, and two, they have an hourly rate that goes way beyond many of the mid-size and smaller publishers' expectations. So that's the reason why we started it. We do a lot of benchmarking, and my advice would be is to indeed what Berendina explained, is to understand how your revenue is built up and if there is room for growth in that area. And our experiences with the publishers that we've worked with, that almost all see growth through a variety of ways, either through an audit of aggregator contracts or via an adjustment of their contracts between, for instance, the authors and themselves, or see a better sales opportunities because of the contracts that they have with libraries. So it's a bit of a mix, a bit of a mixed approach, depending on how the portfolio looks like of you as a publisher. So I hope that explains a bit how you could possibly tackle it, and that is how, at least how we tackle it with the publishers that we work with.
Kush, if you have any more questions, just drop a line. We will always reply.
Okay, thanks very much indeed, Chris and Berendina.
Thank you.
Bye.
Thank you. Bye-bye.